speaking at this session and for conducting. I'd like to just introduce ma'am to the participants. Ma'am is a managing partner at her own firm, Rupandeep Sahni Associates. She has also worked at various firms in India, Germany, and Malaysia, and is also a credited civil and commercial arbitrator. Mediator. Um, Ma'am, anything else that you'd like to add?
No, I think that's enough for it, because we're here to understand arbitration, and let's hope that I'm able to get you guys clear the concepts, and that would be the best introduction that I can
Right.
get.
Agreed. Agreed.
So,
All right, ma'am. We can start now if you are
oh,
ready.
okay. So, hello everybody. Like Veronica just introduced, I'm Rupam, and I've worked in arbitration. I've done my master's from Berlin, and in international arbitration, and thereafter I have worked with various firms and AIAC, the Arbitral Institution in Malaysia, as well as sports arbitration. So now I have my own independent practice, and I look into domestic as well as international arbitration. So enough about me. Now, today we're here to understand a very new concept, which is emergency arbitration. Now, emergency arbitration has taken this whole up game in the recent COVID times, especially. It's a very new concept. So I am going to be presenting with a PPT where I have certain notes and important points for you to read and understand. Whatever questions that you guys might have, we can take a Q&A session at the end. And yeah, just a very small disclaimer: if there is any technical glitch, or if there's any problem, just unmute yourself or let the moderator know, so that we do not waste time and quickly get done with that. And please also be a little patient, because the topics that we're covering are a little detailed. We're covering emergency arbitration as well as fast track procedures. So both are very different to each other, yet a bit similar, that we're going to discuss now. But yeah, it can be a little lengthy. So now, okay. I just hope that it's readable. We're just going to begin with emergency arbitration. Now, like I told you, emergency arbitration is like a form of an interim relief. It's a very upcoming concept in the field of arbitration. It's mostly suitable for the parties that want to protect their assets and evidence that might otherwise be lost or altered. So it's basically, emergency arbitration is a game of time. It's very temporary, and emergency arbitration, like any other ADR mechanism, derives its power from the arbitration agreement itself. So the main role of emergency arbitration comes up when there is no arbitral tribunal in place, or there is a situation where setting up an arbitral tribunal will take a lot of time, and there is no such time. So that's when the emergency arbitration is the emergency arbitral tribunal is constituted. So only mostly two situations: one, when there is no tribunal in place, and second, when the situation is such that there is no time to appoint and go through the entire appointment procedure of the tribunal. So, like I told you, during this COVID pandemic phase, the concept of emergency arbitration has gained a lot of popularity, because of non-functionality of the tribunals regularly. The emergency arbitrator is capable of granting interim measures or relief for just a very limited period of time. Such proceedings are conducted by an arbitrator as per the agreement between the parties, and it's only for the interim relief for a limited period of time. Instead of approaching the national courts, the parties can opt for an arbitrator, again to save a lot of time. So it's the tribunal is constituted for a limited period or for a very fixed limited purpose. So as soon as the purpose is served, or the time frame for in which the issues had to be decided, they lapse, the arbitration ends, the emergency arbitration ends there itself. But like I told you, it's a very relatively new concept in the field of arbitration, and it has been there has been a lot of issues around it with regard to enforceability and recognition, especially in India. But then we see, when is this arbitration applicable? When can you have an emergency arbitration? Now, basically, they are applicable only, in certain scenarios. Where first is most important is when there is an urgent need for party seeking interim or immediate relief. So the relevance of emergency arbitration often arises in situations where a party is, you can say, constrained to seek interim relief. So, the principle of seeking this interim relief is an important concept in the field of arbitration. And instead of it's a very settled principle of law that the any court of law or any arbitral tribunal can only grant such interim relief that are in aid of the final relief. So, like I told you, that the emergency arbitrator gives interim relief. That interim relief has to be, the limited purpose of that interim relief has to be in the aid of the final relief. So the final relief will be given by the normal arbitral tribunal that would be constituted later, but it is basically the in continuation. Next is reasonable delay in formation of a tribunal. A very common scenario again, that there is a lot of delay in cases where arbitration is being passed by the courts to the tribunal, where the arbitration is referred, I'll say, by the courts to the tribunal. That takes a lot of time because the courts have to discuss the validity of the agreement, the clause. So all of that takes a lot of time. Even when sometimes the tribunal is appointed, the proceedings are very consuming. So they cause delay, also, damages to the aggrieved party. In such cases, one party can seek for emergency arbitration. So when the functioning of the tribunal is limited, when the functioning of the courts, like in the present scenario, is limited, a lot of parties have opted for emergency arbitration just to save time and get an immediate relief. Sometimes they have to get the assets frozen, or of the other side, of the other party, or they need a stay that is very important. So in that case, they can invoke emergency arbitration. Next is the jurisdictional dilemma. In cases of international arbitration, between the parties from different jurisdictions, that creates a jurisdictional dilemma in seeking injunction from the courts, meaning by which court or which jurisdiction can a party invoke to seek an interim arbitration, interim order. So that kind of dilemma is there. This kind of dilemma is basically resolved by the emergency arbitration, because an urgent measure or an urgent, the urgent orders or interim orders, they can be applied from any jurisdiction. So the parties to the dispute can refer such a dispute for emergency arbitration before the notice of arbitration is issued and the tribunal is constituted. Like, you would know that in the arbitration procedure, the invoking arbitration is only done by sending a notice, which is a very mandatory procedure. So, but when you have to invoke emergency arbitration, you have to do it before you send a notice invoking arbitration and before you constitute your tribunal. So the award is enforceable like an order of the court in jurisdictions that recognize emergency awards. We'll discuss this ahead, but India, as of now, doesn't recognize emergency awards. However, there have been cases where the Delhi High Court and the Bombay High Court has recognized. We're going to discuss that. So, emergency arbitration is not merely an instant remedy, but is also a facilitator. Sometimes they come to a settlement between the parties before they could initiate arbitration. Approaching the emergency tribunal, they can settle the disputes. Last is the need for fast track arbitration. This is basically not very relevant, but yes, a lot of times people opt for emergency arbitration for a faster resolution of their dispute. Sometimes when they get a faster interim order, which is a status quo, in that case, the nature is quite similar to an ad hoc arbitration, and they just quickly have this. You can say by getting the interim award and the interim measure, the parties can have their arbitration procedure faster, and they can have the resolution faster. And this is where settlement also comes in the picture. So when there is a need for fast track arbitration, you can always opt for emergency arbitration. When there is jurisdictional dilemma, opt for emergency arbitration. Why? Because a tribunal which can give interim measures as jurisdiction can also, the same jurisdiction can form an arbitral tribunal later on after the emergency has been dealt with, the order has been given. Now, this note is very important. It says that most arbitration rules across nations follow an opt-out policy with respect to emergency, which means that only if the agreement between the parties specifically excludes, very important point, specifically excludes emergency arbitrator provisions, would these provisions not apply in total. So if you have an agreement where you are specifically mentioning that the parties opt out, they agree to opt out from emergency procedure, in that case, you cannot invoke. When your agreement is silent, you can make that approach. Then how to apply for emergency arbitration? Basically, it's a similar pattern that needs to be followed, but just two very important factors for securing orders. Under emergency arbitration is that you need to satisfy on two grounds. Now, one is that there is a reasonable possibility that the requesting party will succeed on merits, or if the measure is not granted immediately, the loss would not and could not be compensated by way of damages. If you can, satisfy these two factors, then you can apply for an emergency arbitration. But after the tribunal is satisfied that these two conditions are fulfilled, then comes the mandatory procedure that needs to be followed to commence with the emergency arbitration. And the mandate is that filing of proof of service of such application upon the opposite party. So you have to file the application for invoking emergency arbitration to the other party before you move to the tribunal, and then the payment of the decided fee schedule. So you have to decide the fee of the emergency arbitrators beforehand, and you have to mutually decide, both parties. And there is one thing that is mandatory in emergency arbitration, that it is only applicable to the signatories of the arbitration agreement or their successors, but not to the third party. They cannot be a part of the emergency arbitration. So after basically you satisfy the courts on two factors, then the court admits, the tribunal, admits your emergency application, and then you have to fulfill the two procedural aspects, that is the proof of filing and payment of the fee schedule to the arbitrator. Then we come to proceedings under emergency arbitration. Now, emergency arbitration tribunal is, capable of granting interim measures to parties for a limited time, like we just read. But it also exercises similar, if not exactly same, but similar functions that of an ad hoc tribunal, but only that it is constituted for a limited time, and after its purpose has been served, the procedure lapses. But the emergency arbitrator becomes functus officio after the interim order is made. That means the purpose has been served, so the proceedings lapse. That means the mandate of the emergency arbitrator becomes functus officio. Now, most arbitration rules across nations, I told you, they follow opt-out policy. That is a very important part of the proceedings. If the tribunal sees that your agreement is clearly opting out, in that case, you cannot invoke emergency arbitration. But after the emergency arbitration application is appointed, what happens? Now, the emergency arbitrator shall, as soon as possible, but within 2 business days, of appointment, he shall establish a schedule for considering the application for emergency relief. Schedule is basically that on this date you will file this submission, and on this date then 2 days later you will have a hearing if possible, if required, then or 2 days later I will pass the order. So that kind of a schedule has to be passed immediately within 2 days of the appointment. And basically the schedule is very important part of a procedural aspect in an arbitration. Why? Because the opportunity to be heard, the reasonable opportunity to be heard needs to be assured, so that these schedule, they can provide whether you're getting the oral hearing or not, or whether sometimes the proceedings are by way of a telephonic conference or just by written submission. So this schedule basically sets down that procedure that the tribunal is following in your arbitration. Then, due to strict timelines, the emergency arbitrator may never actually hear or consult with the parties apart from certain major clarification, and just give his order based on the documents and the written submissions placed before him. So this is one of the most important aspect of emergency arbitration, that oral hearings is not mandatory and might not happen. And this is only the similarity between the fast track arbitration and emergency arbitration, that in both of them, the oral hearings can be dispensed with. Now, basically, timelines keep varying under various domestic or international arbitration rules. But a typical emergency arbitration usually takes from 8 to 10 days, from the date of application to the date of award. The emergency arbitration is continued or is finished within 8 to 10 days. That's it. So that's the timeline that needs to be adhered to. Then, the emergency powers of the emergency arbitrator. Now, obviously, most of the powers of the emergency arbitrator is very similar to the ad hoc arbitral tribunal, include such as the authority to rule on his own jurisdiction, like we seen under Section 16 of the Act, or the power to make interim measures of protection. So like Section 17. So the emergency arbitrator has the same power to make such orders as an ad hoc tribunal. Basically the nature of interim orders, this is a very important point, that what kind of, like we know that the emergency arbitration is only for passing an interim order mostly. So what kind of interim orders can be passed? Now they can be passed for asset freezing orders, whether it's prohibitory or mandatory injunctions, then orders for preservation and inspection of evidence, preventive orders to avoid misuse of intellectual property or confidential information, or suit for anti-suit injunctions. Basically, these are all the kind of orders that the emergency arbitrator can pass. Another important point is that the emergency arbitrator's order is not binding on the arbitral tribunal, with respect to any question or issue or dispute which is determined, or the interim order has to be actually at the end, it has to be either varied, discharged, or revoked in whole or in part by the order or the award of the arbitral tribunal. Now that can be done either by the tribunal on its own, or a party can request that. So that kind of interim order is not binding, and the tribunal later on either varies or revokes or discharges that order and gives a final award. So that's more about basically about the proceedings, how the emergency arbitration, when can you apply, how do you apply, and what happens during the proceedings. So just 2-3 things to keep in mind: that the time period, very strict timelines, it has to get over within 8 to 10 days, powers of interim measures, and powers to give to decide on its jurisdiction. That all is there, and mostly the hearing is based on written proceedings, written documents, written submissions, and not oral hearing. I think this is one reason that emergency arbitration has not been recognized in India, because here nothing happens without an oral hearing. So let's see what happens in India. Now, the 246th Law Commission report. Basically, there are no provisions for specific provisions for emergency arbitration in the Indian law. Even after the 2015 amendment, this provision was not there. It did not make it to the amendment. The enforcing an award passed by an emergency arbitrator, lacks legal backing in under Indian jurisprudence even till date. So what happened was that in order to recognize the emergency arbitrations, the Law Commission 246th report on amendment to the Arbitration Act proposed an amendment to Section 2, Subclause D of the Act. So under that subclause, the amendment was proposed for introducing and recognizing basically emergency arbitration. Basically, this amendment was to ensure that the institutional rules such as SIAC arbitration rules or ICC rules or any other rule which provide for an appointment of an emergency arbitrator, they are given statutory recognition in India, because in international arbitrations, emergency arbitrations is a very, very common concept. It is invoked, and it is ever since 2010 and 12, a lot of emergency arbitrations have taken place. But unfortunately, in India, it's not recognized. So there comes a lot of problem with enforcing that order. So that is what was done by under this report, that it was proposed to recognize these orders, but the amendment of 2015 failed to incorporate the recommendation of the Law Commission, and it still does not provide for emergency arbitration. So basically, we do not have a law on emergency arbitration. But we do have institutions and institutional rules for emergency arbitration. So there are many institutions, that recognize, that have rules. In a lot of arbitral institutions in India, recognize emergency arbitration, and they have provided specific rules, because securing, interim relief is obviously a major factor for approaching factor for approaching for emergency arbitration. So, which is why these arbitration centers in India provide for emergency arbitration in their rules. So, what happens is, instead of filing a petition under the act before the court, the parties can approach these institutions for emergency relief. But in case of foreign seated arbitrations, the enforcement of such interim measures passed by an emergency arbitrator remains uncertain, for the same reason that enforcement of interim order passed in a foreign seated arbitration is not recognized in India yet. So the institutions do have the rules, but they can pass the rules if the parties agree and decide. Now, let's take an example of one of the rules that we have in under the domestic arbitration, that is for the Delhi International Arbitration Center, that is the arbitration center under the Delhi High Court. Now that the arbitration center has arbitration rules under section 18A for emergency arbitration, and let's see what it says. Basically, section 18A explains the appointment, the powers, the procedure, the time periods of an emergency arbitrator or an emergency arbitral tribunal. So if a domestic party wants to run an emergency arbitration, it can do so under these institutions. So what happens is, like, upon the receipt of request by a party for appointment of an emergency arbitrator, the secretariat of the institution, with the consent of the chairperson with consent of the chairperson, they shall appoint the emergency arbitrator within 2 days of receiving such a request. Then any challenge to the appointment of the emergency arbitrator must be made within 1 day of the communication of such a challenge to the parties and to the tribunal, and they have to disclose the circumstances of the challenge. So within 2 days, they have to appoint a tribunal, and if there is any challenge to the tribunal, then that has to be done within 1 day by the party who's challenging. And then the emergency arbitrator, the arbitral tribunal so appointed shall again make a schedule and schedule a hearing or schedule the time for filing of the pleadings and documents, but that is generally within 2 days. So the schedule has to be set within 2 days of his appointment, and then he gives a sufficient time, which is again 2 to 3 days, to file all the documents or to conduct any oral hearing if they have to. The emergency arbitrator, again, under these rules, also have to provide an opportunity of being heard to both the parties, equal opportunity, and grant any interim measures that the parties are seeking if it is satisfied that the party has made those grounds and it is valid. So the emergency arbitrator has, under the DIAC rules, the power to grant them. Then it's the same that we've studied, that the parties have to comply with the order made by the arbitrator, and the arbitrator shall ensure that the entire process of the arbitrator the emergency arbitration shall be completed within a period of 7 days. So the arbitral rules itself says that it has to be commenced within 2 days and then concluded within 7 days of the appointment. It does happen, one or two cases have been there where it has been completed within 10 days, but what happens is that in practice the tribunal, the emergency arbitration tribunal, they kind of have validity for a period of 1 month or so. So in that time, they can make an order or change an order if they want. Then this is basically more about the ad hoc or domestic institutional emergency arbitration. So this is a very good landmark case. There are two landmark cases of emergency arbitration in our domestic arbitration. One was the HSBC versus Arbitral, and the other was Raffles Design International India Private Limited versus Educom Professional Education Limited, and others. So they are the two cases where basically the Bombay High Court and the Delhi High Court, the Raffles Design case was passed by the Delhi High Court, and HSBC case was before the Bombay High Court. They had basically they've emerged as a torchbearers. Why? Because the interim reliefs the grant that was granted by the emergency arbitrator was recognized by the court. So what happened in both the cases? So what happened in HSBC was that the case involved an arbitration agreement in which the parties reserved their right to seek interim reliefs before the courts of India, even though the arbitration was actually conducted outside the country. So the parties resorted to emergency arbitration in Singapore, and in the tribunal seated in Singapore gave a favorable order, and but that order was obviously had to be enforced in India. So the Bombay High Court, now if you have to enforce an order of the emergency arbitration that is a foreign seated tribunal, given by a foreign seated tribunal, but you have to enforce it in India because the assets might be in India. So then you have to get it enforced from the Indian courts. So the Bombay High Court in this case upheld the award passed by the emergency arbitrator, and it granted the interim relief that the arbitrator had passed. And it just the court very observed that basically the petitioner has not bypassed any mandatory conditions of enforceability. So in that ground, the courts allowed a direct enforcement of an interim award that was passed by the tribunal. So this was a till date a landmark case, even Raffles Design. Now we quickly move on to the international aspect of emergency arbitration. So for we have the international institutions, that have rules. Basically, since the amendment to the Ancestral Model Law in 2016, it empowered the arbitral tribunals to grant interim relief to parties. So after that, a number of arbitral institutions, they amended their rules and they provided provisions for emergency arbitration. So these are the few of many institutions: ICDR, SEC, ICC, SIAC, HKIIC, that provides rules for emergency arbitration. So like for domestic, we dealt with. I am dealing with only one or two institutions, the rules of one or two institutions, because we are lacking time. But what happens is the rules for emergency arbitration, the institutional rules for emergency arbitration is more or less the same for almost all institutions. Just the difference would be in the fee schedule and maybe the days. Like if under SIAC it's 2 days, under ICC it might be 3 days. Just to point this out, that only the difference can be with regard to the number of days in which the proceeding has to finish, and the fee of the arbitrator mostly. Otherwise, the concept, the rules, the procedures, everything is more or less the same. So we are going to only take up one or two institutional rules. Now, the SIAC. Why SIAC? Because at least in India, the most of the emergency arbitrations are either dealt under SIAC or they're dealt under ICC. So basically, in July 2010, the new SIAC rules came out, which provided for two innovative provisions: emergency arbitration and expedited procedure. Both that we are going to discuss. We are discussing today. And SIAC was the first international tribunal to come up, institution to come up with this provisions of emergency arbitration. First institution in Asia to come up with that. So the emergency arbitrator provisions were, introduced in SIAC rules to address the situation where a party is in need of emergency interim relief before a tribunal is constituted. So the idea again is the same, that before the tribunal is constituted, the rules come in action, the rules for emergency arbitration. Now, what is the procedural rule for SIAC? Like we just dealt with the Delhi High Court Arbitration Center. SIAC rules basically requires a party to make an application for the appointment of an emergency arbitrator with the filing of the notice of an arbitration. Now, this is a different point here, that under SIAC rules, you kind of file the emergency arbitration if you need, along with your notice of arbitration. So you invoke it simultaneously. So then after that, the president of the SIAC court, decides. Typically it's done in a matter of hours here, whether this kind of emergency application to be accepted or not to be accepted. So if he proceeds that yes, it should be accepted, then he has to appoint the emergency arbitral tribunal from the panel of arbitrators on SIAC, with SIAC. So they appoint the emergency arbitrators quickly within hours from their own panel, and the rules require that this appointment be made within 1 business day. And further, once it is appointed, the arbitrator again will set out a schedule for considering this application and deciding this application within 2 business days. So the timeline is that it has to, within hours, it has to either accept or reject the emergency arbitration application. Then within 1 day it has to constitute the tribunal, and within 2 days it has to set out a schedule for the emergency hearing. So SIAC emergency arbitrator, they also enjoy the same powers as a normal arbitral tribunal, like we just discussed, the power to decide on your jurisdiction, or for a portion of cost, or for granting the interim relief. One difference is that unless parties agree, an emergency arbitrator cannot form part of the main tribunal. That is provided under SIAC. That if the emergency tribunal consists of a sole arbitrator, he or she cannot be an arbitrator or a presiding officer for the main tribunal. Obviously, the party autonomy takes precedence here. If the parties want it, then it will be there. So under SIAC rules, the order of the emergency arbitrator ceases after 90 days of its constitution. So I think under the Delhi High Court rule, it ceases after a month and a half. Then the cost. There is a fixed fee of Singapore dollars 5,000 or US dollars approx 4,000 is charged by the SIAC as its administrative cost, and the emergency arbitrator's fee is determined by the registrar. But there is a registrar of the SIAC, but it's always there is a cap, and the cap is subject to the 20% of a sole arbitrator's fee. Now you will find this cap and you will find this schedule under the SIAC rules, and the minimum amount is the I think Singapore dollars 20,000 or something, but it's always at the discretion of the registrar who decides the fee of the emergency arbitrator. Then now the procedure is done, the cost is decided, the award is made. What happens then? The award issued by the emergency arbitrators, they're generally enforceable under Singapore law. So the Singapore's International Arbitration Act was amended in 2012 to provide the enforceability of such awards. And then these orders issued by the emergency arbitrators in Singapore-seated arbitrations and also, outside Singapore, they were all enforced by the Singaporean court. So this actually made the Singapore courts the first jurisdiction globally to adopt legislation for the enforceability of emergency arbitration awards, arbitral awards. So under Singaporean law, they've made an amendment in the international arbitration law itself, and that resonates with the rules of the institution for enforcing the award passed by the emergency arbitrator. Let's quickly have this case from the SIAC itself on emergency arbitrator. So under SIAC, they do not disclose for the confidentiality reasons the name of the parties, hence case study A and case study B, like we deal it in this. So what happened in this case was SIAC basically received an application for the appointment of an emergency arbitrator from the claimant. The president accepted this application and it appointed an emergency arbitrator in respect of the claimant's application. The day after the emergency arbitrator's appointment, the respondent also filed again an application for the appointment of emergency arbitrator, and they allege that they are also entitled to some emergency relief. This was all done prior to the constitution of the tribunal. So now there was basically a counter claim of emergency relief. So the president of the tribunal decided to accept, the president of the institution, it decided to accept the counter application and also decided that the same emergency arbitrator should be appointed in respect of the counter application as well. And then the emergency arbitrator, heard the applications together and it issued separate interim awards in respect of each party. So that is one where, you make counter applications and that is dealt by a same arbitrator. Sorry. Yeah. Then the second case is also very interesting. It's a landmark case under the SIAC rules, and it is between Indian parties. So Indian claimant sought an injunction in this case, restraining the respondent from calling upon the performance of the bank guarantees that were provided under the contract, for services in India. So what had happened was that within 24 hours, a Singaporean arbitrator had been appointed as an emergency arbitrator, and further 24 hours later, a schedule was also established. Like we just discussed, a telephone hearing was conducted in this case, and the bank guarantees were called upon in the meantime, and the emergency arbitrator issued an interim order directing the respondents to deposit the proceeds it had received from the guarantees with the bank to the claimant's credit. Then he also directed that the amount was not to be drawn upon until the final determination by the tribunal. So if you see, all the entire hearing took place within a week, and it took place over telephonic conference, and within 24 hours the parties also cooperated with the tribunal, and the schedule was fixed and the schedule was adhered to, and the emergency arbitral award was passed. So that's how fast and quick SIAC rules are, and its most invoked rules for emergency arbitration. So this is all about emergency arbitration, the domestic, the international, and if you have any questions or queries, we can take it collectively at the end. Let's move to the other topic, that is the fast track arbitration proceedings. Now, what are these proceedings? Fast track, by the name itself, it suggests that they are a faster proceeding, faster than the normal arbitral proceedings. Now, fast track arbitration basically means making an award within 6 months from the date the arbitrator enters appointment. The parties can either choose or decide in writing before or after the commencement of arbitral proceedings to have the dispute resolved by the fast track procedure. So, in this is a very important point, that it's not that the party should always, only before the dispute has arisen can decide on fast track proceeding, but even after the dispute has arisen, they can switch to a fast track proceeding. And the important point is that they need to have it in writing. So that's very mandatory. And in fast track arbitrations, basically tribunals are shall be a sole arbitrator, and he is generally appointed mutually by both the parties. So section 29B, as you've read, of the Act deals with the fast track arbitration. Subsection 3 of section 29B says it lays down the essential characteristics of a fast track arbitration, which is to be observed and followed by the arbitrator. What are those? First is there will be no oral hearing. Like we discussed in our emergency arbitration, that oral hearings are dispensed with. Oral hearings are only and only held if the parties request or the tribunal deems it necessary. Otherwise, it is based on the written proceedings. And I have personally been a part of a fast track arbitration where we had the case resolved within 4 months, and it was only a document based arbitration. So both the parties submitted their written submissions and their pleadings. So they had submitted we submitted our pleadings. Then there was a schedule set. Then the arbitrator asked us to file written submissions, and he passed an award. So it was that quick and easy. So that's the very important part of fast track arbitrations, that oral hearings are not necessary. It's only the tribunal's discretion to allow or not to allow, for an oral hearing. And under fast track arbitrations, the tribunal has the power to dispense with the technicalities with regard to the conduct of proceedings. Now, if you will open the Arbitration Act, and you will see section 10 onwards, section 10 and then section 18 onwards as well, it talks about the conduct of the proceedings. So that procedure, the language, the appointment, the procedural law, the substantive law, whatever the entire part 3 talks about, that can be dispensed with in fast track arbitrations. The tribunal is free to determine any procedure that it deems fit to resolve the dispute, because the aim is only to quickly resolve the dispute. So the tribunal, when the tribunal calls for a written submissions, it can even call for additional documents or evidence or any information from the parties, or even seek clarification if it needs for passing the award. Then, like I told you, the award under fast track arbitrations need to be made within 6 months. Then parties can apply, but if what happens is it has to be made within 6 months. But if the parties are not, if the arbitration is not completed within 6 months due to any reason, then the parties can seek extension of the arbitration proceedings under section 29A, under the similar procedure that is given under section 29A for other proceedings. And what happens is, if practically the court thinks that the delay in such proceedings was due to the arbitrator, due to the conduct of the arbitrator, then the court might not, the court will substitute that arbitrator. It will either substitute that arbitrator with a new arbitrator, or it will reduce the fee of that arbitrator by 5% for every month of the delay. So that is given in section 29A. That applies to this section as well for the purpose of extension, if any. Otherwise, the award needs to be passed within 6 months. Now, what are the essential features of an fast track procedure? The judgment of BCCI versus Kochi Cricket was a very important judgment with regard to the fast track procedures, because it led down the actually for normal procedures also, proceedings also. It said that in this judgment, the Supreme Court held that the fast track proceedings will only be made applicable to the arbitration proceedings that commenced after 23 October 2015. So all agreements, all disputes actually that arose before 23rd October 2015 would not be having a fast track procedure. They cannot opt for fast track procedure because it came with a prospective effect. So only the disputes that arose after 23rd October 2015 could opt for a fast track proceeding. The process, like I told you, is majorly governed by a strict timeline, strict time limit policies, and that has to be complied with by the parties as well as the arbitrator. And because the object, sorry, is to basically quickly resolve the dispute like as soon as possible. Then the application for the fast track procedure is basically done through an opt-in approach. Like we just studied the opt-out in the emergency arbitration. In fast track arbitrations is basically an opt-in approach. Basically, the what it means is that the parties to an arbitration agreement can apply for a dispute resolution through fast track arbitration by agreeing to the same in writing. So opt-in approach means that they have agreed with each other mutually in writing at any stage it can be for having their dispute resolved under the fast track procedure. So they can agree even after the arbitral tribunal has been appointed. They can make a separate agreement and or a contract and agree that now we will have this proceedings under the fast track procedure. So writing, having it in writing is the very important point. Again, consent of parties is very essential. Any prayer for appointment of arbitrator under this section would be premature. Uh, Okay, there was some disturbance here. Yeah. The consent of, like I was telling you, the consent of the parties is very important because unless and until there is a consent of the parties for appointment of arbitrator under fast track procedure, the proceedings would be considered premature. The prayer would be considered premature, and the it would not be allowed. At least prior to the stage of constitution of the tribunal, it would not be allowed. The so you know, a consensual application in writing is very important for fast track arbitration. Always remember that. And you can extend it like we discussed, and similarly as section 29A. Now, if the mandate of the arbitrator expires and both parties do not consent to extend the period of pronouncing the award, a substitute arbitrator, like I told you, can be appointed in his place. Now, there is no fixed set of proceedings or procedure under fast track arbitrations. The tribunal and the parties are free to decide their own procedure under this. And no oral hearings take place. We already discussed that. Then the fast track procedures are basically designed, you know, to reduce the cost and time consumed by the proceedings. So sometimes procedures like examination of witness, they are also kind of avoided under fast track procedures if the tribunal has decided so. Even they proceed for the evidence on the basis of documents itself. So there is no examination of witness that takes place. And last thing is the party autonomy. Obviously, party autonomy is the cornerstone of any arbitration. So it is the cornerstone of fast track arbitration as well. Unless the parties have decided, there cannot be a fast track arbitration. Now, while drafting, you know, what happens is the success of such arbitrations, they are largely dependent on the way your clause is drafted to infer whether there is party autonomy or not. Even you guys as lawyers, as budding lawyers, should understand that while you're drafting a clause for arbitration and for fast track arbitration for your clients, make sure that you do not make an ambiguous clause. You include the ambit of arbitrator's jurisdiction, the number of arbitrators, the scope of arbitration, the time limit permissible, submissions, written documents, what about the evidence and examination of witnesses. All of this, you should include it in your clause so that there is no ambiguity in interpreting, and you can easily take forward this fast track arbitration. Advantages are more or less same that we've already discussed, that it's speed and cost efficient, and it dispenses with oral hearing, so it saves your time and it saves a lot of energy. Then fast track arbitrations are usually beneficial for smaller claims, because otherwise the cost would in case of a very small claim, if you go for a normal arbitration, the cost of arbitration would be much more than your claim, than your award. So fast track arbitrations are less time consuming and less fee consuming, I'll say. So they're less costly, so it's better for small claim arbitrations. Now, the last point is very important, that if you have to maintain in situations where you want to maintain the relationship between your opponent, and the parties want to preserve their commercial relationship, and they want to ensure sustained cooperation or keep the contract afloat, in that case, such arbitrations, fast track arbitrations, are usually the best way possible for resolution of your dispute. So, more or less the same. Then the disadvantages of fast track arbitration, not much of a disadvantage that there is for a fast track arbitration, but you can say that the cooperation, since we know that the cooperation and consent of the parties is very it's the core of fast track arbitration proceedings. That particular point can cause delay in the proceedings, because it is impossible at times to have the consensus between the parties for a sole arbitrator, for example. So fast track arbitrations generally have the concept of sole arbitrators. Even the section 29B talks about appointing a sole arbitrator. In that case, getting the consensus between the parties is one hell of a task. So that causes delay, and that can also cause unsuccessful proceedings. Another very important disadvantage that can be is that a sole arbitrator might lack the expertise or proficiency that is required to resolve this particular matter in a fair manner. Or if the dispute is too complex, or it's a technical case, it's a complicated case, or it involves a lot of parties, then fast track proceeding might not be a good option, because in that case you cannot decide purely on the basis of fast track procedure. So because you need evidence at that time, you need hearings, a lot of things are needed. So in complex cases, fast track proceedings are not recommended. I think that is there, and also in our system, this particular problem of oral hearing, mandatory oral hearing, is there because the judges or the lawyers or the arbitrators, none of them are used to, in their practice, from their practice at the bar, they're not used to deciding a matter without, or negating a matter without any oral hearing. They think it's very important, but in civil law countries, even the normal court proceedings function through only written submissions, and oral hearings are only done when it's very, very necessary. But yes, the arbitration in civil countries run with oral hearing, but the main their substantive law actually provides, the German substantive law is very clear that no oral hearings shall take place unless it is very important, the circumstances require that, or the parties request to, for some reason, only and only then. Then we do the difference between a normal procedure and a fast track procedure. We've, I think, discussed that, but we'll just run through it quickly. In normal procedure, you can have a arbitrator tribunal, but in fast track, you only have a sole arbitrator appointed by the parties. Under the normal procedure, the award needs to be made within 6 months, within 12 months, which can be later extended to 18 months. Under fast track procedure, it is to be made within 6 months, which can or cannot be extended later. Then the rule of payment and costs are determined by the High Court, which means it's not important that it's only High Court, but the schedule that has been fixed under the Act, the cost of the arbitrator can be fixed according to that Schedule 4 of the Act, or it can be fixed according to the agreement between the parties and the arbitrator. But under the fast track procedure, the fee is determined and agreed by the parties and the arbitrator only. The court or the act does not provide for any schedule of fees. So then under the normal procedure, oral proceedings can take place, and the under the fast track procedure, it is usually the written submissions that are relied upon. Then we again come to the this was all about our our arbitration act, what rules are provided for fast track proceedings under our under the arbitration act under section 29B. Now one of the most important you know provisions that you will also see in practice is the ICC expedited procedure. They are massively used, they're extensively invoked, and a lot of cases I think ICC has resolved with the expedited procedure. So which is why I wanted to discuss this with you, because they're very important, and they're very interesting also. Basically the fast track arbitration, the most number of and the most well-known procedure of conducting fast-track arbitrations are done by ICC under their rules. Now, ICC introduced rules for expedited arbitration procedure under their 2017 ICC rules, and under these rules, an expedited procedure would automatically apply to disputes having an amount of $2 million or less. So if the amount is 2 million or less, you will automatically, your proceedings will be dealt under the expedited proceedings under ICC rules. And the parties to an arbitration agreement again could opt out or opt in for the expedited procedure by a mutual consent, especially when the amount is even more than 2 million US dollars. And again, the parties, like I told you, they either have an option to opt out or they either have an option to opt in. And when the amount in dispute is more than $2 million, then they cannot opt out. Then it has to be a mandatory opt-in. But if it's less than 2 million, then they can opt out by consenting with each other. And under the ICC rules, the fee charged for expedited proceedings is 20% less than the regular fee. So they were the first institution to come up with the rules for expedited proceedings, and since they operate on the basis of the amount in dispute, they are they have done a lot of cases under these rules, and they have actually given an expedited award. So how does the clause of ICC looks like in an expedited proceeding? It says that all disputes arising out of or in connection with the present contract shall be finally settled under the rules of arbitration of the ICC by one or more arbitrators appointed in accordance with the said rule. The parties agree pursuant to Article 30, subclause 2B of the Rules of Arbitration of the International Chambers of Commerce that the expedited procedure rule shall apply irrespective of the amount in dispute. Now, what does this mean? Even if the dispute in this case, in their case, is less than 2 million, they will still be guided, they will still be dealt under the expedited procedure rules if they have such an amount, such a line in their agreement that the parties agree pursuant to blah, blah, blah. There is also another provision in ICC where they have, after you have invoked arbitration, that you have invoked the notice, you have, sorry, made the request for arbitration, the ICC gets a form signed by the parties for opt-in and opt-out clauses. So in that, you can choose if you want an expedited proceeding at that time. Then, there is another thing that if the parties wish the ceiling for the application of expedited procedure rules to be higher than that specified in those rules, the following wording wording should be added to the clause, which means that if you have if the amount, the the capping of the amount is higher, then your clause should look like this: the parties agree pursuant to article 32b of the rules of arbitration of ICC that the expedited procedure rules shall apply, provided the amount in dispute does not exceed, you can put your amount, at the time of communication referred to in article 1(3) of the expedited procedure rules. So you can fix you can have a clause in your agreement to fix an amount for expedited proceedings to take place. This happens a lot in the practical world. The parties opt for expedited proceedings for a lot of reasons, and the why ICC is the most commonly used institution for expedited proceedings, because of its clause based on the capping of claim amount. Then comes the procedure that the procedural rules for expedited proceedings under ICC 2017 rules. Again, more or less the same, that a sole arbitrator is to be appointed under the expedited procedure rules, who will determine the number, length, and scope of written submissions and witness evidence at his discretion. So, at his discretion is very important. Now, after the tribunal has been constituted, the parties cannot make new claims without the authorization of the tribunal. So, if the parties have made their documents, filed their pleadings, filed their claims, then they cannot amend their claims after the tribunal has been constituted. Now, this kind of clause is only there in ICC. The sole arbitrator it is empowered to pass an award solely based on documents submitted without oral hearing. So we've gone through this, that for expedited proceedings, the oral hearings are always, or the witness examination of witness is always dispensed with. But if it is required, the parties request, or the tribunal thinks it necessary, even it can then order for hearing. But in the case of ICC, the tribunal will have to go through the authorization of the institution as well, if under the expedited procedure they are opting for oral hearing. So that's a serious matter in ICC. Then obviously the arbitrator shall make an award within 6 months again from the date of referral to arbitration, and that is done under the Article 4(1) of the expedited rules. The procedural hearing, the first procedural hearing usually takes place within 15 days after the arbitrator has received all the pleadings and all the written submissions. Then within 15 days, the first procedural hearing takes place. And that can either be through teleconferencing, or it is even through email. Now, I have witnessed one. I have been a part of an arbitration that was held in Paris, where the arbitrator was based out of Germany, and the proceedings were to take place in Paris with ICC. So the parties were also based in Paris. So the arbitrator, instead of holding any hearing, the arbitrator actually communicated with the parties through email only. The arbitrator set out the schedule, and gave us through an email. Then he would given all his procedural orders through email, and we would file our submissions, and everything took place on emails only. And we got our award within, I think, 5 months or so. We got our award. So that's how the expedited proceedings under ICC takes place. Now, this is important. Where does these procedures, expedited proceedings, do not apply? The arbitration agreement, which was concluded before 1st March 2017, they cannot opt in for expedited proceedings in any which circumstances. Only all agreements which were concluded after 1st March 2017, only they have the option for opt-in, and the clause for $2 million will only be applicable to the agreements that were concluded after 1st March 2017. Then obviously the parties have agreed to opt out of the expedited procedure. If they have given their consent in writing that they do not want expedited procedure, then it will not apply to them. Or if the court, the ICC court considers that no, this case cannot be dealt in under expedited proceedings because it's a very complex matter. If we will, quickly do it, in that case, there can be a problem. Especially in cases which involve governments from a foreign to foreign governments. In that case, there is a case that we did again before the ICC where the case involved a government party. So the court decided that no, if we allow the expedited proceedings, then there would be a problem later on for enforcement, and we should not, because the witness in that case was in America and in USA, and the only way possible to be having the the witness was to have an examination of that witness through video conferencing, but that could not be done under the expedited procedure, and that was very important. So the court decided that ICC court decided that no, in this case, the expedited proceedings will not be applicable to the parties. Then the claim is for declaratory or non-monetary relief. In that case also, the expedited proceedings will not be applicable in ICC. It's not the case under our domestic law 29B. Only under ICC expedited proceedings, if there is only a declaratory order or a non-monetary relief, which means there is no dispute of US dollars 2 million, then the expedited proceedings will not apply. Like ICC, the next would be SIAC. Now, the SIAC has similar rules for fast track proceedings. And again, after ICC, one of the most used institutional rules for expedited proceedings, and have observed many expedited proceedings, now, ever since 2010, actually. These rules came out in 2010, and the rules were applicable in appropriate cases where the parties have agreed to refer their disputes to arbitration under the SIAC rules. Now, a party may make an application for the expedited procedure prior to the full constitution of the tribunal. So if the full constitution, let's say there was a 3-party tribunal and only the presiding officer is yet to be appointed, then the parties can opt in for expedited procedure. But after the tribunal has been constituted, it's not possible. Then the application for expedited proceedings can be made where the amount in dispute does not exceed the Singapore dollars 5 billion, and where the parties so agree, or in cases of exceptional urgency. In all these cases, the parties can make an expedited procedure application under the SIAC. Obviously, the president of the Court of Arbitration under SIAC, he determines to either accept this application or to not accept this application. And if the president decides to accept the application, then the case shall be referred to the sole arbitrator. And unless the president agrees for a 3-tribunal arbitrator, which is generally not so much in SIAC rules, and the award has to be made again within 6 months from the constitution of the tribunal, and only under exceptional circumstances the SIAC court, the SIAC court can extend this time. This is a case of Hamara Pump Mithora HPCL. I'm so sorry. Versus chairman cum managing director of Hindustan Petroleum and others. This was a case of a fast track arbitration. Very simple case. In this, the Allahabad High Court held that the fast track arbitration has to be made in writing, and it should be consensual between the parties. 2 most important points for fast track arbitration. So it was held, the same was held in this judgment. In the other judgment of Crayons Advertising Private Limited versus Bharat Sanchar Nigam Limited, the Delhi High Court held that the consent of both parties was required to extend the mandate of the arbitrator. So in the absence of mutual consent, the mandate of the arbitrator stood terminated and the court appointed a fresh arbitrator to continue the proceedings. And this happens under 29A also. You can only apply for extension of further 6 months of your proceedings if both parties consent. If one party does not consent, then the mandate of this arbitrator cannot be extended. A fresh arbitrator would be appointed. Another case is, this is also a very good, very landmark, good case under the SIAC rules for expedited procedure, where the Singapore, High Court upheld, the award issued under this expedited procedure. In that case, basically the parties agreed to arbitration in accordance with the SIAC rules by 3 arbitrators. Now, the defendant applied for the arbitration to be conducted in accordance with the expedited procedure. After considering the views of the parties, the president accepted the application and appointed a sole arbitrator to decide the dispute, whereas the parties had decided the 3 arbitrators. But after an award was issued against it, the plaintiff filed an application to set aside the award on the basis that the arbitral procedure was not in accordance with the agreement of the parties. The plaintiff argued that the arbitration should not have been conducted before a sole arbitrator as the parties had expressly agreed to 3 arbitrators. But the High Court ruled that the expedited procedure in SIAC rules 2010 can override the parties' agreement for arbitration before 3 arbitrators. Now, what happens is that Singapore as a country is pro-arbitration country. So they try to uphold the rules that the institution has made. But, it's not generally the case in every jurisdiction. If the parties have not have agreed to a 3-member tribunal and a sole arbitrator is appointed, that is a procedural defect that can be very well challenged before the court, and the award can be set aside on that ground alone. So like we know that any court having a pro-arbitration approach will always give priority to the arbitration if the parties have an intention to resolve their dispute through arbitration. Otherwise not. That's more about more or less all about fast track arbitration. We come to the end of this webinar, and emergency arbitration and fast track procedures, they have become a very important component of international commercial and even domestic arbitrations. Only the emergency arbitration in our domestic world is not so much common, but after these institutions have come up with their emergency arbitration rules, I think there would be more of emergency arbitrations, the institutional arbitrations coming up. More so, the new Amendment Act is again, the courts are in favor of institutionalizing the entire arbitration proceedings. So in that case, the emergency arbitration will start being recognized in our country. However, I would say that the Delhi High Court has a very pro approach towards the emergency arbitrations. But I think that it's very important that the fast track procedures should be taken up, because they cut down the lengthy procedures and the formalities, especially for oral hearing and all. From my personal experience, I think the fast track arbitrations are way more healthier and better for your client and for parties themselves, for everybody, because you deal with the merits of the case in a more simple manner, and there is no scope of having any delay tactics adopted by any of the parties. With this pandemic, emergency arbitrations have taken a big leap, and our firm is coming up with the concept of Court of Innovative Arbitration, which we call as COIA. And if I get another chance to meet you guys again, and by that time, if my institution would be launched, I would be very happy to share with you what all COIA is about. But under COIA, we kind of are coming up with only fast track procedure rules, that the proceedings will only be through written submissions, no oral hearings, and it's going to be a fast track procedure. Especially, we have divided the type of cases. In simple cases, the awards will be given within 1 week. So there would be a panel of arbitrators that we have, so that there is no problem with the parties. The parties will have to mandatorily appoint the arbitrator from the panel, so that we keep the system very intact. And we will be having a panel of international arbitrators as well as domestic arbitrators. So I think the trend should be that this kind of setup should be more and more adopted. The lawyers should make an endeavor to promote fast track arbitrations, and the courts should make an endeavor. I think that the emergency arbitrations should be recognized, because that will be a welcoming step. It will be effective also in providing dispute resolution mechanisms. So that's from my end. Thank you very much for being so patient and for taking the lecture. I hope it was all clear and it was informative for all of you. And we can now have the questions if there are any.
Yes, ma'am, we'll proceed towards questions now. Do you want me to read it from the chat box, or will you?
Oh, are there other questions there in the chat box?
Yes, yes, I'll read it.
I'll take the questions. Don't worry.
All right, all right.
Okay, now.
If anybody has
I'm-
questions, they can also turn on their
Yeah.
audio and ask. That will also work.
Yes, I'm so sorry. Somebody wrote that my voice is breaking. I did not check the chat at that time. So you can ask me whatever was not understood then. So I take the first question. It says, can the order of any emergency arbitration tribunal be used as a precedent in other emergency arbitration cases? Yes, they can be. But again, what happens is if the emergency arbitration order is passed by an international, tribunal, a foreign-seated tribunal, using that as a precedent before our Indian arbitral tribunal might not work, because, like I told you, that India still does not recognize the emergency arbitrations as such. They do not enforce the emergency arbitral orders. So you can use very well the precedents from one, if your facts allow, but in foreign seated arbitrations you can. So the next is, what is the subject matter that can be dealt with under emergency arbitration? Are the merits of the case also discussed, if only in a summary manner? The subject matter basically is same, like we say that the disputes that are capable of being arbitrated, the arbitrability of disputes, no rights in rem, and no rights, no guardianship matters, no family law matters, they all cannot be subject matter of emergency arbitration. But all your civil claims, your commercial claims, your financial claims, all other claims which are capable of being arbitrable, which are capable of being decided by arbitration, they can very well be dealt under the emergency arbitration. But you have to be very particular, keeping in mind the interim relief that the act provides. If the act prohibits that the interim relief cannot, the arbitral tribunal cannot give an interim relief beyond such scope, then even an emergency arbitral tribunal cannot move beyond that scope. So merits of the case is not discussed even in a summary manner. They are not discussed in an emergency arbitration, because, like I told you, emergency arbitration is only a form of granting an interim relief. It is a hearing which under which you only grant interim relief, which is taken ahead by the final tribunal that is constituted. They take ahead the merits of the cases, not the emergency tribunal. Then I have this question: what are the possibilities of inclusion of emergency arbitration clause in the rules of Indian arbitration institutes? Well, the Indian, like we just discussed about the Delhi High Court Arbitration Center, they do have emergency arbitration rules, provisions, in their rules. There are even other, what do you call, institutions that have the rules for emergency arbitration, such as the Mumbai Center for International Arbitration, the Nani Palkiwala Arbitration Center, Indian Council of Arbitration, Madras High Court Arbitration Center. All these institutions, Indian institutions, they have provisions for emergency arbitrations under their institutional rules. Next question is, so for a fast track arbitration, should it be in written in the contract arbitration clause itself, or can be written at a later state as well? It can be both actually. The criteria is that it should be written now, and it should be mutual with the mutual consent of the parties. So the parties can either write it in a contract while they are entering in the contract, and which means before the dispute arose, or they can make a contract or a separate contract for fast track arbitration even after the dispute arose. And in some cases you can also, opt in for fast track arbitration even after when your tribunal is constituted. There are exceptional cases like that. So basically you can always opt for fast track proceedings, but what you cannot do is that the tribunal has been constituted and you move through your arbitral proceedings, and in the middle your pleadings are completed, your the time of evidence has come now, and in the middle of evidence the parties say that okay, now let's go through fast track arbitration procedure because it's taking a lot of time. No, you can't do that. What you can do is, if your mandate of arbitration has expired, you move to the court for extension. There you not move to the court for extension, but you let the court know that you don't want this arbitrator because he's taking a lot of time, so fresh arbitrator be appointed. Now at that time, when you're getting a fresh arbitrator appointed, you make a contract of fast track arbitration. Then you can again begin, you can be governed by the fast track arbitration rules in that scenario. Otherwise, before the dispute has arisen or after the dispute has arisen, anytime you can have a contract for fast track arbitration. Sagar Agarwal has asked that if a Section 9 petition is filed after obtaining the emergency award order, does the High Court take into consideration the order of the emergency tribunal, or entirely different proceeding takes place? Oh, it's a very good question. See, it does. The proceedings for Section 9 is the interim award that is given by the court. It is a separate proceeding. Why? Because under Section 9, you make a petition for granting interim relief to the court itself. You do not go before the tribunal. Now, if you have approached the emergency tribunal before moving to the court under Section 9 and the tribunal has given you an order, then that order will take precedence. The High Court, however, has the power, has to to set aside that award, that set aside that interim order that the emergency tribunal has given, and it also has the power to recognize, like we had studied in the case of Raffles and HDFC. Yeah. So in both the cases, the court had recognized the interim award that was given by the tribunal. Now, if you are moving to the tribunal before, then the court has the power to either revoke it or to recognize it. But if you are moving to the court, that's an entirely separate proceeding. For having the interim measures, you cannot proceed simultaneously to both. So, any other question, guys? These are the only one that I can read.
Any question, guys? Any more questions? I think that's it.
All right. So thank you very much, everybody. It was great having you all.
Thank you very much, ma'am. I'd like to thank on behalf of the entire ILS ADR cell. The session was really insightful and helpful. The concepts explained were you explained them in quite detail. The emergency arbitration and fast track procedures. And we hope to see you again. Because of this pandemic, we have to do this online.
Yeah.
So that's there. But we hope to see you again physically sometime soon. And it was a pleasure to host this meeting. Thanks to the participants also. I'm sure